Hello and welcome back to the lecture series for the preparation of CLAT examination. In this particular lecture series, we were discussing about law of torts in our previous video. Uh, Throughout this lecture series, we have been dealing with a lot of subjects. We have dealt with the law of contracts. We have dealt with the Indian Constitution. We have dealt with the criminal law, and post completion of all these subjects, we have resorted to the law of torts. In our previous lecture, we have discussed thoroughly about what exactly is law of torts. We have talked about how law of tort is being governed in the Indian society, being a common law subject that has been derived from the English Constitution, and what exactly is the need of law of tort being implemented in the society that is India, and how is it helpful for us. So we came to know that law of torts, when we talk about torts, what we are going to discuss was that how this is going to provide a compensation being a civil wrong, and how it is going to be helpful for the person who has been the victim in a particular wrong that has happened. We have talked about the torts, we have talked about the definition, we have talked about the derivation of tort from where it has been derived. We have talked about the latent terminology that is tortum, and which means twisted or crooked. And post that, we have talked about the consequence of tort, where which we have talked about the wrongful act, then the damages that it causes, and obviously after that, we have discussed the legal remedy that is available. We have tried to understand that how the law of tort is different from the criminal law, it is different from the civil law, and how it has have been a blanket over the criminal law and the civil law, meaning which how it has providing an extra support to the criminal laws as well as the civil laws, how it is being governed in the society, and how it makes sure that the principles of natural justice and the rule of law is being maintained in the society. Law of torts, when you talk about competition of CLAT examination, becomes a very important subject, because there are very few things that needs to be taken care of when we talk about law of torts. And in our previous lecture, I have informed you about that whether it should be set as law of tort or law of torts. This was a question that was given to all the viewers to figure out whether it is law of tort and law of torts. And I suppose you must have gone through the Salmon's definition of torts, where which he has explained the pigeon theory, in which he has said that if, let's take an example of a pigeonhole where different pigeons are there, so in the same manner, their thoughts are there, where which there are different thoughts that takes place in the society. So considering it, whether it is should be considered as a law of thoughts of or law of thought, this was the question. So the answer of the same would be that it is considered as law of thoughts and law of not law of thought. The reason being there are different thoughts, different wrongs that are happening, and they have been considered as thoughts. So when we say that it is law of thought, it means we are talking about the generalized concept. And when we say thoughts, we are talking about the wrongful acts that has taken place in the society, and what are the remedies accordingly that we figure out. So, in this particular lecture series, before we start this particular lecture series, I would like to take some of your time so that I can explain you that if you're planning to give CLAT competitive examination, what are the things that a CLAT aspirant should make sure, should keep in his mind to understand, and to get to that understanding, to get to that knowledge, that whenever we are talking about competitive examination, what are the things, what are the essentials that one has to take into consideration, and how we are going to plan to prepare for that particular examination. Because teaching principles and the concepts obviously is something that we are going to do in our lecture series. But often it has been seen that even after providing efficient lectures, providing good support, the students are not able to cope up with the competition, and they eventually fail to succeed with the flying colors with good marks in the competitive examination. So I would like to first explain you the do's and don'ts that are there, that one has to keep into consideration whenever they are planning for any competitive examination. So this let's talk about the competitive examination of CLAT. I suppose the screen is visible to you. So if you talk about CLAT, there are 5 subjects that we are taking into consideration, and one subject that we are obviously dealing by ourselves is legal reasoning. Legal reasoning. The point of concern whenever we talk about the CLAT aspirants is that once they have the paper with them, so let's take the example that this is the paper, and there are many questions that will be present in front of you, and if these questions are there in front of you, often what student does is that they start from question number 1, then they approach to question number 2, 3, and so on. But the problem, what we have observed as examiners and expert for competitive examination, is this approach is perhaps not going to be beneficial in a longer run. And the reason for that is that competitive examinations has a mixture and amalgamation of different subjects, and practically it is impossible for almost everyone to retain each and every concept whatsoever they have studied. I'm not saying that nobody can do it, but in my past experience, I haven't seen anybody who can claim that they are 100% confident and 100% sure that they are going to excel in this examination. The reason for the same is that it requires a lot of practice, it requires a lot of revision to clear these examinations. And often what student does is that if they have 100% syllabus, they will try to complete 100% of the syllabus, and when it comes when the examination is scheduled, they are not even able to retain 60% of what they have studied. So the point of concern here is that if the student has completed 600% of the syllabus, if he has completed 100% of the syllabus, but he is not able to retain even 60% of the same, then the chances of him excelling in the examinations will obviously reduce. So what should be the correct approach? Whether it should be completing the whole syllabus first, and then practicing the questions, and then trying to revise it, whether that is the right approach, or there is some alternative that the student needs to follow in order to ensure that whatsoever they have studied, whatsoever they have completed is rock solid, and if there is any question that is going to come from the concepts that they have learned and they have practiced, they are able to solve those questions accordingly. So the very first approach which I recommend to all the students, all the CLAT aspirants, is not to use this traditional approach of solving 100% of the paper, because you need to understand that you have negative marking also. So you have negative marking. So when you talk about negative marking, what should be the approach? The approach, if you talk about, let's take the example, there are 150 questions that we need to attempt in our CLAT examination. And during this examination, you have only allotted 120 minutes, which means that you have only a stipulated time period of not more than 40 seconds, not more than 40 seconds per question. Now, if you talk about 40 seconds per question, it becomes perhaps very difficult for the candidates to even read the questions, forget about answering the same. So first and the foremost thing which I recommend to all the student is to inculcate the habit of reading. The reason reading, and reading with pace. Because once you have inculcated the habit of reading with pace, you will be able to understand the questions very easily and very efficiently. And once you have understood the question, it should not be your approach that you directly try to figure out the right answer. If the first method and the first approach whenever you get the paper in front of you is to understand those areas where which you can assure yourself that you are going to score 100% of 100% marks. So let's take the example that there are 150 questions, and out of those 150 questions, once you see the paper, the first question which is in front of you, you don't know the answer of the same. Then you approach to the second question and you see that I might know the answer, but I'm not 100% sure that this answer is right. For the third question, you see that this perhaps also I don't know the answer. Fourth question, you figure out that no, for this answer, I am 100% sure that this will be the correct answer. This option number A, B, C, and D. So let's take the example that B is the correct answer. Now, if we talk about CLAT examination, out of these 150 questions, nobody can assure that how many questions they are going to mark right. But there is a cutoff. And why we are discussing this? Because obviously practicing and understanding the concept is one portion of making people acquainted by the syllabus and obviously complete the whole syllabus accordingly. But the approach, seldom is being given to the candidates, that how they need to practice the paper, how they need to approach the paper. And approach is perhaps very important whenever we are trying to solve any competitive exam question paper. So the approach should be correct. So let's now take the example that out of these 150 questions that you have in front of you in CLAT examinations, the first four questions, as I've just told you, you are not sure what the answers would be. So what should be the approach? Should we start marking the answers accordingly and then we'll change the answer? No. That is not what we are going to do. We are going to read the whole 150 questions in one go. In one go, we are going to read these 150 questions, and for only those questions in which we feel that we are 100% sure, out of this 150 questions, out of these 150 questions, let's take the example that you are 100% sure that around 60 questions you have marked correct. So the initial phase should be not attempting those questions where which you feel that you are 100% not confident, but rather approaching towards those questions where which you are 100% confident. So out of 150 questions, let's take the example that you are 100% confident for 60 questions. Now you have marked the right answers according to you, and you feel like that this 60 questions which I have attempted in my first attempt, when the paper was given to me, I can assure that these 60 questions are 100% correct. So once you have done that, after reading the whole 150 questions, you have done marking, you have marked 60 questions where which you are 100% sure that these answers are right. So in that you have secured around not 50%, but at least 40% of the marks that is required to clear the examination. Okay. Because nobody is going to secure 150 out of 150 in your examination. Nobody is going to secure this much of marks. The threshold, the cutoff often is seen in between 120 to 130. So what we need to do is we need to assure that we are securing our marks in between this particular range so that we can get a seat in CLAT examination. And how we are going to do it? So first approach, 60 questions we have marked and we are 100% sure that these answers are right. Now, how many questions are left now? How many questions are left? There are 90 questions which are still left in the question paper. And now, how we have to approach it? That after marking those 60 questions right, we will see through it that out of these 90 questions, what are those questions which we can feel that, okay, 70% we are correct and 30% we are not sure. Or maybe 50% we know the answer, 50% we don't know the answer. Then we try to mark those questions. Okay. So let's take the example that out of these 90 questions, we happen to mark 60 questions again, which we were 50% sure that this might be the answer. So if we talk about probability, if you have studied probability, you know that if we are talking about 50% of the chances that we might have secured. So the worst case scenario would be that out of these 60 questions that we are 50% sure, there will be 0 answers right. In this particular instance, the chances of students securing the rank is almost now negligible. But if we being optimist and if we see through it that out of these questions, out of these 60 questions in which we are 50% correct, we are able to get at least 30 questions right. So if we are able to get 30 questions right, so it means that 30 questions here and 60 questions there will be equal to 90 questions. So we have out of 150 questions, we have marked 90 questions, and these 90 questions we are pretty much sure that these 90 questions will be correct. And at that same point of time, there were 30 questions that we might have marked incorrect because we were not sure about the same. And if we talk about the negative marking, it is talking about 1/4. 1/4 of the negative marking is there for a CLAT examination. So if we talk about 1/4 of 30, so 1/4 of 30 will be around 7.5 marks. So we have reduced 7.5 marks from our total marks that we might be scoring at this point of time. Correct? Now we are left with how many questions? We are left with still 60 questions. Out of these 60 questions, we have to see that how many questions we can attempt to secure a good position, and our aim should never be 150, but it should be in between 120 to 130 only. Reason being, the cutoff shall be between in this particular range only. So after attempting in the first attempt, when we were given the question paper, we solved 60 questions which gave us 60 correct answers. Then in the second attempt, we figured out those 60 questions which we are 100% sure that we are not 100% sure, but rather we have a 50-50 chances that whatever we are marking is right. So out of those 60 questions, let's take an approach that we are able to solve 30 questions right. So now we have got 90 questions correct, but 30 questions again we have marked wrong. So it has reduced 7.5 marks from our whole tally whatsoever we have secured. So if we are reduced from 97.5 or maximum 10, so now we are standing at 80 marks. So now we are standing at 80 marks, and we still need to get 40 marks out of these 60 questions that are there. Now it is obviously a very challenging portion, because the chances of us getting correct answers from areas which we are not 100% sure is very difficult. So now what we have to do? Now what we have to ensure? What we have to ensure is, so whenever we are attending paper for the first time, at least we need to mark 50% of the questions correctly. That is 100% chances of getting them correct. And once we are able to secure 50%, that is 75 questions, right? So we are left with 75 questions. Out of these 75 questions, we take out 60 questions again, where which we are 50% sure that this will be the answer. So 30 questions we are again able to mark right. Now the tally goes to 105 marks. Now out of the remaining, how many questions are there? The remaining questions are 25. All we need to do is we have to make sure that we are marking at least 15 questions right. So once we are able to mark these 15 questions right, the total tally will be 120. And once we are able to get to that level, so this is the minimum threshold limit. This is the minimum threshold limit that we need to do in order to assure ourselves that we are able to mark the answers correctly. The reason for me to explain you these thing is because you might be well versed with the concept and you are well versed with the pattern of the paper also. But often it has been seen that the students start tackling questions in a wrong manner. They start with question number 1, then they go to question number 2, 3, 4, and so on. And once they are stuck over a particular question, they try to solve that question, leaving behind the important areas where which they could have secured more marks. Because we need to understand that all the questions carry equal marks. So if we are stuck over one particular question, it means that we are reducing our time and chances of attempting the other questions. Until unless you have not attempted the questions, even if you know the answer right, you will not be able to get marks out of it. So what we need to ensure is that we are actually going through all the 150 questions in one go. We are marking at least 50% of the question, that is 75 questions should be marked correct. And once we have done with it and we have completed this whole work period within, let's say out of 120 minutes, we have completed this work in 50 minutes. Okay. So now we are left with how many? 70 minutes still is left with us. 70, 50, 120. So 70 minutes is still left with us. 50 minutes, we are able to solve 75 questions. And 50 minutes, how you're going to solve those 75 questions? You have to maintain a very high speed of reading. And how we are going to maintain that? We are going to not only study the syllabus of CLAT examination, rather we will inculcate the habit of reading newspapers also. Once you start reading newspapers, whether it is English, whether it is Hindi, and I would recommend if you're going to give papers in English, then you should start reading English papers only. Whenever you'll read, you will see through it that how you are approaching a particular paragraph. Because in the CLAT examination also, you know that there will be paragraphical forms questions. There will be one paragraph, and after reading that paragraph, you will be able to solve the questions. So it is very important that you make sure that there should be time management. There should be correct approach whenever you are solving the papers, and inculcate this habit whenever you are solving mock papers also. You allot a time of 120 minutes and you start solving the papers and see through it which is your strong areas and which is your weak areas. And once you have done with analyzing what are your strong and what are your weak areas, you divide those areas into 3 columns, where which A will represent those areas where you are 100% sure that I have completed this particular subject and I can solve any questions that is going to come within this particular subject, from this particular subject. Then comes, and let's take the example, there are 2 subjects where which you are 100% sure that you will be able to solve these questions if any sort of question will be asked. Then comes those subjects or those topics where you have read it, you have understood it, but you are not 100% sure. Not 100% sure. Here, for these subjects, we need to constantly revise it. And practice questions so that all those subjects who are falling within this column should be moved to column A, meaning which now you are 100% sure over these subjects also. Now comes the C column, where which all those subjects we have not studied it, and we need to make sure that these subjects which we have not studied, we are at least going through the important concepts. Now we don't have that time where which we are going to again focus over 100% of the syllabus. But the correct approach says that you focus over 60% of the syllabus, but you should be 100% positive and confident that if there will be question from this area, that 60% of the syllabus that you have studied, you will be able to mark all the questions correctly, confidently. So what it will ensure? It will ensure that even if the student has not studied 100% of the syllabus, their chances of getting qualified for competitive examinations like CLAT will be perhaps much more higher, because you will not be getting questions from each and every topic. Mark my words. So there are areas which they are very important, and it has been repeatedly asked in your question papers. For example, if you talk about injuria sine damnum and damnum sine injuria that we have read in Law of Torts, this is a very important question concept, and there are high chances that you will be getting questions from this particular area. So what we need to make sure? We need to make sure that we are, so I suppose this concept is clear, that you need to have A, B and C columns, where which you will be dividing the syllabus accordingly. I have a thorough knowledge of constitution, so I will put it in column A. I have thorough knowledge of law of torts, I will put it in column A. I am not sure whether I can solve intellectual property rights question, but I have studied it. I have studied, but I am not 100% sure. I'm not 100% confident. So I will be putting it in column number B. International laws, I have not at all studied. Now, whether I should start studying it or I should just keep it on hold and I should practice the other subjects first. What we need to do is we need to just keep it on hold until unless there are last 5 to 6 days left for an examination. And we need to make sure that till the last 7 days of your examination, we have at least 60 to 70% of the syllabus in which we are 100% confident. And once you have completed, we have practiced those areas which are important and which you feel that now I'm 100% confident over these subjects, then you need to tackle with the column C, the 30% of syllabus. And in that, only important concept you need to deal. The reason being, once you have thorough knowledge of 70% of the syllabus, and let's take the example that out of this 30%, you are sure of 50% of the syllabus, because you have completed the important portion, important concept you have read. For example, if we talk about international law, you know that jus cogens, pacta sunt servanda, United Nations Charter, principles of United Nations, and reasons for its setup, organs of United Nations, are the important concepts and important topics where there has been repeated questions that has been asked in competitive examination. So we need to figure out those important areas which are important in the remaining syllabus, and we will tackle that syllabus in the last 7 days, along with the revision of all those subjects where which we are 100% sure. So I've completed the law of contracts. Now what I'll do is I will make a make a routine where which I am going to study constitution for 1.5 hours or maybe 45 minutes, and I'll just quickly revise all those things that I have obviously studied and I'm well acquainted with. Why we need to do it? Because there are high chances that when you go and attempt the paper, you need to be 100% confident that you have studied that and the answer is this only. Because there will be confusing options that will be in front of you. And until unless the student is not 100% assured of what he is marking is correct, his answers cannot guarantee that his selection in CLAT examinations. So the approach, again, I will like to tell you what should be the approach. So the approach would be, out of these 150 questions, first I am going to mark 75 questions 100%. 75 questions that should be 100% correct. After marking these 100% questions, 75 questions which are 100% correct, I will resort to those 50 questions or maybe 40 questions which I feel that 50% of them might be correct. And after marking these questions, I will approach towards those questions where I am not sure at all. And then I will mark those questions accordingly. We need to see that if out of this 150 questions, if you are able to score 100 questions which are 100% correct, then your chances of securing a good rank in CLAT examination will be pretty much high, because you have marked 100 questions which are 100% true, and the remaining 50 questions, now what you need to do is you need to see that only through those questions you are marking. Now you are not going to mark any questions which we feel like, okay, that could be the right answer. We are only going to mark those questions where we have 50% chances. Only those questions. Because if you have 50% chance, then there is a high probability that you will be able to score 25 questions correct. So if you mark 25 questions correct, the total tally would obviously be going to 125, and you getting selected now is pretty much sure. It is pretty much sure. So this is how you need to attempt the paper, not in one go, but rather in 3 attempts. And how you're going to revise and how you're going to remember and how you're going to prioritize the subjects. We are going to divide the subjects into 3 portions. Portion number A, portion number B, portion number C. Then we're going to make a column, and then we have to mark. This is constitution. I am 100% sure of it. This is contract. I am 100% sure of it. This is tort. I am 50%, 60% sure of it. This is international law. I haven't studied it. So our main notion should be to constantly revise these subjects. Constantly revise subjects which are falling under the A column. For B, it is not the revision, but study. Study and then attempting PYQs of these subjects. Once you have attempted the PYQs, once you have studied the subject thoroughly, and now you have built confidence after solving the PYQs that yes, now I'm acquainted with this particular subject, shift the subject from column B to column A. Now tort is also under column A. And now what we need to do is we need to start constantly revising these subjects. Now you need not solve MCQs for them. Now you need not study extra in regards to these subjects, because you have thoroughly gone through the concepts, you have practiced the papers, and then you are 100% sure that yes, I can mark these questions right. Once you have marked and all the columns within this B is over and is shifted from B to A, And now you have to approach the subjects which are under column C. You have to study the important concepts only, because for A and B, all the subjects that we have studied, that will comprise 70% of the syllabus, and the remaining 30% is what we are going to do now. So for that 30% which is falling under the C bracket, we will take into consideration only the important concepts, and we'll try to solve questions based only on those concepts. And we are going to leave those concepts which are new to us, which we have not studied. So we are not going to take those concepts and we're going to study, and we're going to now invest our time over it. Because when the last 7 days will be there, our main focus should be to constantly revise and give as much mock test as we can. So it will ensure that the candidate, this is perhaps the perfect approach for any competitive examination, that once the candidate has completed this process, they will be pretty much sure that these are the areas where I can secure good marks. I am 100% confident, not even if not 100%, maybe 90% or 80% confident that if there will be questions, if not complicated, but normal questions, the difficulty level being in between medium to hard, I will be able to solve those questions. Then your preparation is fine, because nobody on this planet can guarantee that if you have studied all the subjects, you will be able to secure a rank. It always depends on your hard work, your consistency, and there is always a luck factor that is involved. So why am I telling you all these things? Because we are studying the concepts, we are studying the principles, we are studying what the syllabus wants us to study. But how we are going to make sure that whatsoever we have studied, whatsoever we have learned through this lecture series is going to be beneficial for us when we are going to give this competitive examination. So we are going to make sure that this particular lecture series is going to be beneficial by using the correct approach, by solving the questions not in one go, starting from 1 till 150, but rather randomly jumping over those questions where which we are 100% correct, marking those questions right, then moving forward with the questions where which we are 50% sure, and then resorting to those questions where we are not at all sure. If we see through it that we have already passed the threshold limit of 120 marks once we have started solving the question paper, then there is no need of attempting extra questions, even if there are slight chances that whatsoever you will be marking is correct, because we don't want negative marks. That negative mark should hamper your preparation. So I suppose it is pretty much clear to you that how you need to attempt the paper and how it is going to be beneficial. And if you follow this approach, if you apply this approach in your preparation for the competitive examination, I personally can guarantee you that you are going to excel. The only caveat is that you should mark the questions in these brackets A, B, and C only when you are being honest. Even if you have 1% doubt that no, I am not still 100% sure that the law of tort is completed, you don't need to shift it from column A to column B, from column B to column A. Until unless you are not sure, you are not going to move any subjects that is in column B to column A. Once you are 100% sure that yes, I am well acquainted with the subjects, shift it to column A and only start revising. Don't give a mock test over those subjects. Don't try to understand don't try to get the extra knowledge from these subjects, because in the end of the day you need to understand this competitive examination is not going to provide you an employment, but rather an opportunity to learn law. So if you are going to learn law, what you need to make sure is that you are not delving deep in the research and studies over subject, but as already told by the consortium that all you need to do is you need to understand the law superficially. So once you are acquainted with the superficial concepts of the laws, then it becomes a very easier task for you to solve the questions. So I suppose now it is a little bit clear to you how you're going to approach the questions, and I am really I really wish that if you use this pattern, if you use this tactics to solve the question paper, then it will be going to be very much beneficial for you. With this, let's start again with the law of torts. We have taken a lot of time. We have been involved in how to attempt the paper, and perhaps that is also important. Studying the concept and studying the principles is important, but studying how to approach the paper is also perhaps important, and that is what I wanted to discuss with you guys. And let's come back to the law of torts. We have studied the constituents of torts. We have studied about what is exactly the difference between the law of torts and law of tort, and what is the difference between law of torts and the other portions of law. What is the criminal law and tort law difference? What is the civil and the tort law difference, etc. And we have studied about the wrongful act. What exactly constitutes wrongful act? We have studied about the legal damages. We have studied about injuria sine damnum and damnum sine injuria. We have studied about the legal remedy that is available because, and on this basis only, the whole law of tort is based, that whenever there is a wrong, there is a remedy. There is a remedy. Yes. So the law of tort is based only on this concept that when ubi just ibi remedium, which means that whenever there is a wrong, there is always a remedy present. We have talked about injuria sine damnum, which we learned that it is only when there is a violation of legal right. It is only when there is a violation of legal right you can approach to the court and demand compensation. Demand compensation. But if there is a damage but no violation of legal right, then no remedy is available. We have studied about the Ashby versus White case, which we understood that, okay, even if the candidate is not able to cast his vote, he was given this and eventually the person in favor of whom he was willing to cast the vote eventually won the election. So it becomes now only a violation of his rights, because there was no damage as such, because the main reason for him to cast the vote to make sure that the other person wins, and that person have already won. So there was no damage as such, but yes, since there was a violation of his legal right to cast the vote, there was it was considered to be a damage as such, and he was given compensation. Opposite of it is damnum sine injuria, which we studied about the Gloucester Grammar School Gloucester Grammar School master case. And in that particular case, we have discussed about how there was one school, and in that vicinity there was another school that was open. From this particular school, all the students migrated to the new school that was there, because of which the previous school have suffered significant loss. And it was observed that since there was no breach of legal right, then it is not maintainable in the court. Only on the basis of the violation of legal right, only on the violation of legal right, we are going to get compensation and claims whenever there is a tort that is happening against us. We have studied about we have studied all those things in a thorough manner. In this lecture series, we are going to talk about the general defenses that is present. we have taken a little brief in our previous video, but today we are going to discuss it in details, and post that we are going to discuss the different type of torts that are present. So let's talk about the very first law of the defense that is available if there is any tort that happens in a society. And these defenses, these general defenses, can be used by the accused to save himself. So these defenses can be used by the accused to save himself, the first and the foremost being voluntarily non-fit injuria. And the best example to understand voluntary non-fit injuria would be a stadium where the candidates have gone to watch a match, and there are chances that once the ball has struck thoroughly by the batsman and it went outside the stadium, there are chances that it might injure somebody who has come to spectate the sport that is happening in that particular stadium. So this particular person has voluntarily, knowing the fact that once the ball will be hit firmly, and the chances of the person who is the spectator is pretty much high, that person has voluntarily given his consent that if by any chance, by accident, I happen to get hit by the ball, I'm not going to claim any sort of compensation from the batsman or the stadium or any of the authorities who have organized this particular match. So this defense is often being used in these type of situations, and I suppose you are able to correlate it, that even if there is a match that's going on, and let's take an example, I being the spectator there, I got hit by the ball. I cannot go to the court and say that I was hit by the ball and now I need compensation, because the court will itself say that you by yourself decided to go into that particular stadium. You knew to the danger that is there, that apparent danger is there of being hit by the ball, and even after that you decided to go and watch the match. So there is no compensation that we can give it to you, because you voluntarily given your consent to suffer from, say, if a person voluntarily gives consent to suffer from harm himself, then he is not entitled to remedy under the law of torts. I suppose it is clear to you. Voluntary non-fit injuria. Voluntarily allowing to suffer harm. If you're voluntarily allowing to suffer harm, then it is considered as voluntary non-fit injuria, a general defense in tort. You can take that particular example for a better understanding in regards to when a doctor is doing surgery. So you by yourself has given him consent that you can use a scissor on my body to make a cut and to do the surgery. And if there is any problem that I might face in future, I have by myself given the consent, if you happen to act in good faith. The important requisite is that the person who is being considered as the accused is doing things in good faith and not in bad faith. So if there is good faith, if the person is doing things without ill intentions, then the general defense of voluntary non-fit injuria can be taken. So the first concept, voluntary non-fit injuria, important concept, you need to remember and retain it. Okay, there is a case of Hall versus Brookhands Auto Racing Club. It is perhaps the same which I have just cited you. The example was the plaintiff was a spectator during a car race. There was a collision between the two cars. One of the car thrown among the spectators, thereby injuring the plaintiff. It was held that here the defendant was not held liable. The maximum voluntary non-fit injuria was applied. Yes, you got to the understanding. Now there is one thing which is known as the plaintiff's default. By the mistake, by actions or by mistake, of plaintiff that tort has occurred. So for this, we will just go through the example. The mere fact that the plaintiff was wrongdoer doesn't entitle him from recovering damages from defendant for wrongful act. Extirpe causa non oritur actio is the latent terminology, the maxim on which the plaintiff default has been based. From an immoral cause, no action arises. Very important general defense that you need to remember. The first was voluntary non-fit injuria, and the second one being plaintiff's default. Let's move forward. There's a case of Bird versus Holbrook. Very important case. This case will be asked in your competitive examinations, so you need to remember this one. Bird versus Holbrook. In this, the Bird is the defendant here, sets a spring gun trap. So there is a spring gun trap in order to avoid people from entering into the gardens of the defendant. The spin gun trapped injured Holbrook. Okay, so the Holbrook, this is another person, was trapped by the spring gun that was set up by the defendant, that is Bird, which injured Holbrook, and it was Holbrook who was injured by that spring gun trap. So now the question was whether, since the injury was done to Holbrook, whether Holbrook should be given compensation for that injury by Bird or not. The court suggested in a negative terminology and said that the Holbrook has trespassed, and trespass means entering into some another's property without getting permission, without authorization. If you're entering, it is considered as trespass. And trespass, if you talk about criminal, so it can also be considered as house trespass or house lurking, which is obviously an offense. So trespass is an immoral act, and because of doing the trespass, you got injured, then you cannot claim any sort of compensation. If it happens that there are certain people or certain burglars who want to enter in my property, and while they were entering into property, one of them got injured, severely injured, while climbing my wall, and then he goes to the court and say that I was I didn't have the intention to steal anything. I was just trying to clear the boundary, and I just want to climb the wall, and that is what perhaps I was doing. So this type of defense cannot be claimed because he was actually involved in some wrongful act, and the defense of plaintiff default can be applied there, even if he has, even if he's not been able to steal anything or do anything wrong to the property. But since he has trespassed, he has done an immoral act without the permission of the person to whom the property belongs. He have entered that property, then the person shall not be given any sort of compensation, even if he is injured, because it was the mistake of the plaintiff because of which he has suffered the injuries. I suppose this particularly is also clear to you. Plaintiff default. Okay. Now, inevitable accidents. Inevitable accidents we have already studied under the Indian Penal Code. General defenses that we have studied there. So I wish that you should be just pausing the video here and you can just read the things out so that you can just revise it, because there is nothing new and nothing different that what we have studied in our previous lectures and what has been written here. So you can just pause the video here, watch it, and if there is any confusion, then obviously you can resort to the bare axe that is available for law of torts. I don't feel like that this inevitable accident is something that you won't be able to understand. Okay. The case law is important. Stanley versus Powell. It is an important case of inevitable accidents. Plaintiffs and defendant were the members of a shooting party. So there was a shooting party that was going on, and Stanley and Powell both were the members of the shooting party. Defendant, being Powell, was focusing on a peasant. So let's take an example that he might be an animal. I'm not sure what a peasant is, but let's take it as an animal. On one of pellet from his gun hit the branch of the tree that changed its direction and accidentally wounded the plaintiff. Since it was a sheer case of accident and was not foreseeable, defendant was not held liable. Now, is it clear? Stanley versus Povil case, very simple case, very important case also, and this gives you another case law with relations to inevitable accidents. And if there will be any sort of questions in regards to inevitable accident, all you need to do is to understand the concept that if inevitable accident has occurred, no matter how immoral the paragraph might sound to you, since you have understood that it is an inevitable accident, then the defendant shall not be held liable. I suppose the third concept of general defense is also clear to you, which talks about inevitable accidents. Let's talk about act of God. Act of God is nothing but extraordinary occurrence of circumstances which could not have been foreseen and guarded against more accurately due to the natural cause, directly or exclusively, without the human intervention. This is a very important thing that you need to remember, because there will be questions where the paragraphs would show, which reflect that although there was an act of God, but there was intervention of the human, because of which that particular calamity has occurred. So if there is even slightest percent of chances that calamity might have occurred because of the intervention of the human, then this particular defense of act of God cannot be taken into consideration. But if there is no human intervention, then the general defense of act of God can be taken into consideration. The only requisite for that is that there should be extraordinary circumstances, and because of which there is a certain loss, and that loss is because of the natural causes, not because of human intervention. Okay, so these are the two essentials for the act of God. There must be working of natural forces. Okay, so there will be natural forces. Natural forces means there can be flood, there can be earthquake, there can be rainfall, heavy rainfall, there can be drought, there can be cyclones, etc. All these falls under act of God. And this particular act of God is also known as one more thing, latent terminology, so that there might be a chance that if instead of act of God, it is mentioned as vis major, so you people are not getting confused. Vis major and act of God perhaps means the same thing. And the second requisite is that occurrence must be extraordinary and not one which could have been guarded against. So if there are chances that we know that there is going to be rainfall, and we happen to vacate the whole area where there are high chances of getting rain, and this might cause calamity, and instead of doing that, we are not doing anything, we are just sitting idle, thinking that it is an act of God, and in the end of the day we can claim damages, then it is not true. Because we have to see that even after making sure that we are trying to evade that particular calamity from happening, only after we have made thorough safeguards and thorough chances of getting calamity is reduced, but still if we get the calamity, then only we can claim this defense of act of God. So we have to ensure by ourselves that we are doing enough to restrain that act from happening. But even if it occurs, then it is considered as act of God. Nicholas versus Marshland, important case. Nicholas versus Marshland is an important case, a famous case of act of God. You need to study it because it is a very important topic. I have not mentioned it because, as I have told you, that from now onwards, I will be providing you a little bit of questions for your better understanding, so that you also are actually involved in this lecture series. So you also get to know that what are the things that has to be studied and what are the things that we are not going to be focusing on. So Nicholas versus Marshland, I would request you all to go through the facts of the case, what exactly happened in the case, and what has the court given as the judgment in this particular case law. Now, private defense. Private defense we have already studied under the Indian Penal Code. That is what we are going to discuss here again. When we talk about the right of private defense, we are talking about the law permits the use of reasonable force. Now, the first thing requisite is that there should be reasonable force. Private defense doesn't mean that if somebody has slapped you, you murder the other person. This shall not be considered as private defense. Private defense as such means use of reasonable force so that the person's body or another person's body to whom they are acquainted or the person's property can be put in such a situation where which the apprehension of danger can be removed. The apprehension of danger, the moment the apprehension of danger is removed, the right to private defense also gets exhausted. So it is very important that we are applying reasonable force to protect one's person or property. If the defendant uses force which is necessary for self-defense, he will not be held liable to be caused thereby. The use of force should be justified only for the purpose of defense. Okay, it should not be like if I slapped you, you're going to murder me, that because this is reasonable ground. No, it is not. Because all we need to make sure is that this right to private defense is given to everybody, the reason being so that they can safeguard themselves. But it is not given as a weapon, but as a shield. So if you're using it as a weapon to cause harm to the other person, then it cannot be considered as private defense. And that is why it has always been recommended that if you happen to be in such a situation where which you have to use private defense, you have to make sure that you are not using anything contrary or in a fit of rage or anger which surpasses your defense and it causes injury to the other person. So we have to be within a justified limit to use the force in order to stop any person from harming ourselves. There should be imminent threat to a person property. Imminent threat is very important here, because when we talk about imminent threat, it should be immediate. A was beaten by B on Monday. On Tuesday, A goes to B house and started beating him. Stated, I exercised my right to private defense. Can it be held correct? Is it okay that if A has beaten B, A was beaten by B, so A went to on Monday and then A went to B's house with a stick to beat him, whether it will be considered as private defense? The answer is no. Why is it so? Because there was no imminent threat on Tuesday. There was no imminent threat on Tuesday over A. So he exercising the power of private defense has already exhausted. Had this been the scenario that while B was beating A, used a reasonable force, then it would have considered as private defense. But if he happens to go and start beating on the very next day, the imminent threat has already been removed on Tuesday. So the private defense cannot be entertained. I suppose it is clear to you that for private defense, we need that there should be a justified force. In it, it should be in relation to person who is trying to cause harm to you or to your property or any person who is of your acquaintance. And the threat should be imminent in nature. There should be imminent threat that if at all I am not using that particular defense, I might be severely injured. So this is your one more defense in regards to torts. And the force should not be excessive. The Bird versus Holbrook, I have just explained you the case. Yes, but now I would reiterate you so that you can understand what exactly happened and what the court said. The court said, in the case of Bird versus Holbrook, if you remember, that there was installation of spring guns by the defendant, let's take the example A, and when there was a trespass, so it was held that I was using my right to private defense, and since the other person has already done a guilty act, a wrongful act, he should not be given compensation. The court held that the use of spring gun is not justifiable as use of spring gun it itself is too excessive and can cause life-threatening injuries. So the use of force here by Holbrook, who happened to be the defendant when Bird was actually trespassing over his particular land. So this particular defense cannot be taken. Had it been some another, maybe fencing, or maybe a dog, or maybe somebody who would have exercised a justifiable force, then it would have considered justified. But the use of spring gun is something which is very powerful, and it might cause life-threatening injuries to the victim. And that is why the defense that was used by Holbrook in the previous instance and in the same instance also, both the same, even if Bird was the wrongdoer, but since Holbrook has used excessive force, so his defense of his defense that I was using my right to private defense, and that is perhaps the reason I've installed it, was not considered to be valid, and he was asked to compensate accordingly only for the loss that Bird has suffered because of the injury. And yes, Bird was also asked the reason why he has done trespass, because it is also an immoral act. But both the parties were asked to compensate each other. So this was the whole crux of Bird versus Holbrook, and this case is actually important. The reason being, it is covering two of your important general defenses, one being the plaintiff's default and the second one being the use of excessive force under the right to private defense. So I suppose this particular thing is also clear to you, that what exactly is in this private defense. Now, necessity. Yes, I have not read it, but I suppose you might have read it again along with you, that it is not necessity. If you have caused damage because there is a necessity, then it is considered to be a general defense. For example, somebody is inside a house which is burning, and there is an infant who is inside. Somebody enters into the house without the permission. He has done trespass. But why has he done trespass? We need to understand. That person did the trespass in the house in order to save the life of the infant who was stuck inside the house. And it was necessary for him, since there was nobody present, it was necessary for him to get inside the house, take out the infant so that he can save the life. So this necessity is obviously justifiable, and it cannot be taken as an action against the person who have worked in good faith, not in bad faith, but in good faith, in order to save the life of the victim, or maybe of the infant, or any other person. So that is why necessity is considered to be a good defense when you talk about tort. So whenever we are studying tort, all we need to understand, we need to take into consideration two things in mind. First, that there should be a legal right that is available. Second, whatsoever has been done in good faith. If we retain only these two concepts, that there is a legal right, and if anything has been done in good faith, then that the court will ensure that thorough compensation is given. And if you're being the victim, then obviously thorough compensation. And if you being the defendant, then if you fall within this necessary brackets of general defenses, you can use this defense to save yourself from the burden of compensating the victim with a huge, enormous amount of money. Salus populi, this is a supreme law, which means welfare of people is the supreme law. Salus populi, welfare of people, supreme law. Understood? This is a case of Lees versus Gladstone. Forcible feeding of hungry, striking laborers to save her life was held to be a good defense. Clear? So necessity is also something that we have completed. Now let's move forward. There's another case. I suppose you can just read it. I just pause the video and read it so that you can understand. I have talked about mistake in our previous video. We are not going to deal with it now. That it is neither considered to be a good defense, no defense there under the actions of tort. When a careful interferes with the right of another person, it is no defense to say that he had honestly believed that there was some specific justification for this. So mistake cannot be considered as a valid defense when we talk about the defenses, general defenses that is available. With this, we have completed the general defenses that is there when we talk about the law of torts, and in detail we have understood that how these general defenses can be used in order to save the defendant from any sort of compensation that might be awarded to the victim. So in order to safeguard yourself from the torts, these are the good defenses that you might use. The first being voluntary not fit injuria, second being plaintiff's default, third being plaintiff. After plaintiff default, we have studied act of God. We have studied about private defense. We have studied about inevitable accidents, and we have studied about necessity. So these specific areas helps us out in understanding that what are the general defenses that we can use for any of the torts that has happened. Now, after we have understood, okay, that if there is any tort and if there is any general defense that we can apply, then the accused, the person who have done the defendant, can be safeguarded, can be saved from being charged for doing any tort. But what are the different type of torts? Now that is what we are going to understand in our upcoming video. Not in today's video, but in upcoming videos, we'll be discussing about all the type of torts, and that will be the end of the law of torts. We will be covering each and every topic. Defamation, we're going to study in detail. Absolute liability, we are going to discuss the case of MC Mehta versus Union of India, which it was Justice Bhagwati who pronounced absolute liability, while referring to the case of Ryland versus Fletcher, which provided us with strict liability. So strict liability was an English law concept, and absolute liability is an Indian law concept. In India, we follow absolute liability if there is any threat or imminent danger in carrying out any business or act. And if there is imminent threat and danger, and even if by chance, by maybe not because of intention, but by mistake, even the person there is a escape of that dangerous substance from that particular area which causes loss, then there cannot be any defense. There is no defense for absolute liability in India. And there is one case of MC Mehta versus Union of India. You might have seen the Bhopal gas tragedy. This is actually the case where which we have studied the case of MC Mehta versus Union of India because of the Bhopal gas tragedy. And what was the timeline? How we in India, we have inculcated the practice of absolute liability and rejected the theory of strict liability in areas where which there is imminent threat or danger that if there is any sort of escape from any of the containers or any of the places where which this particular act or business is being carried out, and this particular business is of such a nature that if there is anything, any object or anything coming out of escaping out of that particular area, it is going to be a life-threatening situation for the people who are in vicinity of that area. Then it is going to be the absolute liability of the owners of the business to make sure that if there is any sort of escape, then they shall be held liable and they have to compensate the person to whom there is a loss that has occurred. We're going to study about the intentional torts. We are going to study about intentional torts like assault, battery, trespass, etc. We are going to talk about the constitutional torts. We're going to study the negligent torts and what exactly is vicarious liability and defamation as such. So these are the things that we are going to study in our upcoming videos. Till that, I would like to request you all to be consistent and try to practice as much as possible and to revise as much as possible. And do remember and do retain the approach of solving the paper which I have just explained you in this current video. That is perhaps very important for all the CLAT aspirants who are planning to give their examination, that they use the correct approach whenever they are solving the competitive examination question paper. With this, I would like to thank you all to be present here. And I wish you again the very best of luck for your preparation for your CLAT examination. We'll meet in the next video where which we are going to discuss the topics of tort, and that video will not be of hard length. It will only be of maybe 20-25 minutes, where which we will be completing the whole topics of torts, and we will quickly revise all the things that we have studied in the law of torts, and then we will keep it in column number A, as I just informed you that how you are going to maintain it, and we'll start practicing the questions accordingly. So law of torts is going to end in the upcoming lecture sessions, and then we are going to again continue with the law with the Constitution of India, because we have left it in middle because we wanted to complete this particular subject, and then we will start back with Constitution. We will take 2 more lectures to complete those complete the important concepts of constitutions, and after post completion of these 4 topics, we would be completing law of contracts, we will be completing constitution law, we have completed IPC, and then we'll be able to complete type of the law of torts also. Post completion of these 4 subjects, we'll start with the lecture series, we'll start with the practice series of these 4 subjects for a continuous period of maybe 3 to 4 days, which we'll try to understand and analyze that what type of questions are being put forward in front of the CLAT aspirants when these topics are being taken into consideration. We'll try to solve the PYQs of these topics, and once we are well acquainted by these topics and understanding of these topics are clear to us, we'll move towards the another topics that are left. We will be talking about the international laws, we were talking about the intellectual property laws, and we were talking about obviously family laws, that is a little bit there in your examinations, and obviously the legal maxim that we have to deal with, then the case laws that are there. So with this, I would again like to thank you, and we'll meet in the next video. Till then, bye bye guys. Thank you, and take care.